Hello, everybody. Thank you, organizers, dear colleagues. I'm very proud and honored to be here at this event and to take part in this debate, and actually to follow with my presentation the wonderful presentation given by Vladislav. So today I will present on a topic that is very much connected to the methodology that courts have used. That is what Vladislav has just discussed in the context of the ICJ. And I will present a paper that I have entitled Eureka on courts' discretion in ascertaining rules of customary international law with ascertaining into inverted commas. In this presentation, I would like to focus on a question much neglected, in my opinion, in international law scholarship, or maybe just to offer a new angle to explore questions surrounding the ascertainment of customary international law rules. Namely, the discretion of the judge or of courts in the ascertainment of these rules. The argument I contend is that the methodological lens which informs the discourse about the ascertainment of rules of customary international law closes the margin of discretion that courts enjoy, and it likely leads our scholarly discussion to a bad point. Before unfolding my argument, I wish to introduce some caveats. First, the use of the term ascertainment does not, at this stage at least, purport to embrace any particular view on legal interpretation. I understand that hermeneutic activity, creativity, or activity of understanding a certain given meaning is beyond the scope of the focus that I want to give to the presentation today. Hence, the term ascertainment, determination, and identification are used in this presentation as synonymous. Secondly, discretion is admittedly related to one's understanding of the judicial function and to what this entails, and I think Vladislav made reference to non licet, or should entail, in the interpretation of international law. The judicial function, as much as the notion of legal interpretation, would deserve a presentation in itself and will thus be beyond my purpose of today. So these two topics will be incidentally touched upon only insofar as they are necessary to explain my arguments. As such, my presentation does not seek to offer any ambitious solution to the questions that have puzzled the minds of many scholars before me, but just offer a new pair of lenses for the context in which we frame issues of the ascertainment of customary international law rules. So I will proceed by providing some background to my argument, and I think Vladislav has made much of this effort already. Explain my contentions and illustrate them by way of practical example, and finally offer some concluding remarks. A conspicuous number of scholarly contributions on the theme of customary international law has tackled the identification of rules under the umbrella of a methodological dualism between induction and deduction. Induction indicates a method of extrapolating a general rule by observing specific instances of practice. Deduction is instead a method whereby a specific rule can be logically inferred from generally accepted rules or principles. Filling lacunae by identifying rules of customary international law is a canonical example of deduction. So the ascertainment of rules of customary international law has been typically inserted in this methodological dualism between induction and deduction. Lawyers find existing legal rules on the basis of empirical material, state practice, and opinio juris. By deduction, instead, lawyers find the legal rules by logically deducing them from existing axiomatic principles and rules of international law. For instance, the principle of sovereign equality between states or the principle of good faith. And the arrest warrant case that has been cited, as well as the Gulf of Maine case, are good illustrations of how deduction has been used. Notably, while induction is portrayed as an empirical grounded exercise, therefore objective, deduction is presented as a logical exercise, thus disguising the margin of maneuver that interpreters enjoy in ascertaining rules of customary international law. However, the methodological dualism between induction and deduction is too ambitious and short-sighted at the same time. It is too ambitious because it presumes that an extensive review of empirical elements would point to the existence of a single legal rule presumably existing out there. And it is too short-sighted because it disguises as empirically or logically based the argumentative nature of statements or claims purporting the existence of a rule of customary international law. Therefore, it also disguises the role that judicial discretion plays therein. So I submit that, against this background, my submission is that the methodological dualism informing the discourse on the ascertainment of rules of customary international law shall be revisited to reflect the argumentative nature of such an ascertainment. An alternative dualism between discovery and justification may instead be suggested, and some of those that I have read proper may relate to this suggestion, which aims to establish a certain kinship with the old dualism, but at the same time to situate it in the realm of legal argumentation. This twist is conducive to unveil the range of discretion exercised by courts in the formulation of rules of customary international law, instead of embracing the methodological lens, which rather mystifies it. Courts, accordingly, operate within an argumentative framework, in that they necessarily select and appreciate evidence of practice and opinio juris, which is far from being incontrovertible, let alone fully representative of the majority of states. In other terms, the selection and assessment of state practice and opinio juris are but the result of an act of judicial discretion, which is obscurely surfacing every act of legal interpretation. However, and this is the second limb of my argument, although courts operate within an argumentative framework and the ascertainment of rules of customary international law stems from an exercise of discretion, still courts' pronouncements are propedeutic to the very existence of these rules. As such, the legend of discovery may be worth believing. In other words, owing to the authority of courts in a legal order, their formulation of presumably existing rules of customary international law is a necessary endeavor for the materialization of such rules and their function and fruition in the legal practice. As I said, I suggest a shift from a methodological lens to an argumentative lens. What does this imply? It implies that the dualism between discovery and justification, instead of being portrayed as a methodological lens, is presented as an argumentative choice. Discovery enables courts to portray the ascertainment of customary international law as an act which does not depend on the discretion of the judge, but rather sets the court in the context of exploring an objective reality, and you see here the kinship with the old dualism. This ascertainment confers to customary international law an aura of objectification and divests it of the potential criticism as judge-made law. However, engaging in discovery does not transcend the justification of what has been arguably discovered by reference to evidentiary elements. On the other side of the spectrum, a court may engage in the ascertainment of rules of customary international law, starting off with a hypothesis about a possibly existing rule of customary international law, perhaps even desirable in an international legal order, and then justify this rule by way of legal arguments. Although this court does not place itself within the context of exploring an objective reality, still the court formulates a hypothesis about the existence of a rule of customary international law as a reflection among other things, of a certain normative ideology. Judicial discretion looms precisely in making these hypotheses, in hypothesizing the existence of such legal rules, which may hinge on an ideal which a court seeks to realize. So the portrayal of discovery reinforces the image of an objective law and of an objectively correct interpretation thereof, while justification is revealing of the fact that the different simultaneous plausible interpretation of facts and of legal rules are possible. So emphasizing the subjective element that is involved in this ascertainment exercise. So now I will continue with two key implications that I would like to stress. One key implication of this shift entails looking at opinio juris and state practice as evidentiary elements rather than truly constitutive ones which are persuasive because they are traditionally accepted as necessary ingredients to a claim of customary international law. As questions about the existence and content of rules of customary international law are addressed within an argumentative framework, it follows that by way of legal justification, these findings need to persuade that they are legally correct. A second key implication of this shift entails that criteria or meta rules envisaged as universal methodological roadmap to the ascertainment of customary international law, such as those proposed by the ILC, are instead arguments restraining the discretion of interpreters with special regard to courts. For example, what is to be considered as a constitutive element of custom, how much weight shall be given to this element in ascertaining the existence of and the content of rules of customary international law. So discretion plays a role in many aspects of this ascertainment exercise. Courts may interpret differently different evidence. They may consider quantitatively insufficient certain state practice to prove the existence of customary international law. One such example is given by Judge Tanaka in the North Sea continental shelf that stresses the delicate and difficult matter of assessing and analyzing evidentiary elements. Similarly, two cases drawn by the ICTY, the ad hoc tribunals are a special example in this regard, given the mandate to interpret and apply rules that were beyond any doubt crystallized in customary international law. So, for instance, if you contrast the Erdemovich case, in particular, the separate opinion of Judge MacDonald and Fora and dissenting opinion on juris, with the Furunja case and the opinion of Judge Robinson, you would see that judges appreciate and require different threshold of evidence for the existence of customary, for a claim to the existence of customary international law. Yes. Given the time constraint, and thanks to the chair for recalling this, I'll conclude by a reflection on what is then that we are left with, and maybe we can discuss this in the process of the debate. Thanks.